Well, hello students and welcome to the week 7 lecture for LW305 for 2024. Today we're going to cover quite a lot of ground and there are links to additional materials throughout the lecture notes, and I'm going to be referring quite a lot to your topic notes and your other materials. So you probably want to listen to this lecture in several sittings and make sure you access your other readings and materials and go through them as you work through the lecture. First, what we're going to do is discuss the ideal role of law in society. We'll do that for a couple of reasons, which we're going to discuss later on. But then going to take a closer look at a reading that was allocated in week 4 on the ideal types of society by Etzioni. I hope you've already read it. After that, we'll move into why law perhaps doesn't always achieve why we want it to in society. We'll then introduce Powell's minimum standards framework as a way of analysing or brainstorming and developing ideas about those problems with law, and what the solutions might be for different issues we encounter in society or that we identify. This is going to be pretty important for your assessment for the course. It's also going to be significant for any of you interested in policy or public opinion or how the society you live in is governed. Now, you could pause the video here, but just let me speak first. The question I have for you is, what do you think the role of law should ideally be in your country? Let's just confine ourselves to thinking about state law. Custom might still exist and be a separate thing, but what should the ideal role, or what should the role of state law ideally be in your country? Well, we might lead our thoughts with a few questions. How much influence do you think law should have in determining what you are allowed to do and what you are not allowed to do? How much influence should our community have in a village setting versus a city setting? Should different groups or different lawmaking authorities have the authority to make laws affecting only particular regions, groups, or places? How much influence should our friends, family, and peer groups have over what we can do? Think about when you're young. Your parents have a lot of control. As you grow older, you gain more independence. If you live with many generations of your family, perhaps if you're younger, there will always be some level of hierarchy or hierarchical influence above you. If you're older, perhaps you're the one doing the influencing and everybody in the household does what you say. How much influence should our environment have over what you're allowed to do? For example, if you're standing inside a courtroom, how does that environment shape what norms of behavior are, or what you feel you should or should not do, or cannot do? Compare that with a tutorial room or a school computer lab. What are the similarities or differences between there and a courtroom? What about a rugby field? If you're standing on a rugby field holding a ball in the middle of a match of rugby, people are allowed to tackle you. Why? Well, because you've consented to physical contact while on that rugby field, or you're in the wrong place. And our environment shapes what laws even apply to us. Isn't that interesting? Just by being in a specific place, the law can be different at a particular point in time. Laws regarding assault or criminal offences don't apply for the duration of a rugby game unless a person goes against the rules of the game or does something else that could actually be assault. That can still happen, but not common assault. But how different should it be? What's ideal? What's right and what's wrong? Should different laws and rules apply in different places? different islands, different communities. In rugby, we couldn't have the game at all if those rules weren't different from everyday contact and conduct of people. By the same token, we couldn't have the game of rugby if different places didn't all play by the same rules and play by the same rules when they were playing against each other as part of a competition. Who develops and maintains the rules of the places that govern conduct? Whether it's on the field of rugby, whether it's in society, whether it's within an office or building. Does the International Rugby Board have absolute authority over what happens in a local rugby match in Suva or Auckland? Probably not. Probably not at the most junior of levels. They might. There might be a technical way that it's all accredited up to the International Rugby Board and it must be adjudicated in Lausanne, Switzerland or something. That's quite probable. Although the rules, I guess what I'm saying there is that they make rules at a global level and they do filter down to high school and even in the remote places of our communities. Those rules of international rugby sort of filter down in some way. What about international law? The international order, CEDAW, treaties. Should all rules have certain principles in common? Should all rules be fair? Should all rules be fair? That sounds like a good thing, doesn't it? We like things to be fair, and rules should be fair. But how do we make rules fair? Who makes the rules? Who enforces the rules? Are they biased? Aren't we all? How do we ensure the rules are applied fairly? So, for you in your society, what do you want the law to produce? Do you want the law to be strictly and rigidly enforced at all times? Or do you want the law to be flexible, depending on the circumstances of each case? That there's some flexibility. So where do you draw the line if there's going to be flexibility between an individual's rights and the necessary and appropriate restrictions on those rights? Where should the line be drawn between an individual's obligations to others as part of a society and reasonable release from those obligations? Consider scenarios like during COVID of no jab, no job, a policy in Fiji. What should be the case? When should it be acceptable for a private or for a government employer to restrict opportunities for employment? So, for example, if I hire you to drive a bus, before you apply, I require you to have a bus driver's license and a clean driving record. My company's got a good reputation. We only hire the best qualified drivers. If I hire you to work in a crowded environment or interact with other staff or customers, I might require you to be vaccinated. I might even pay for the vaccination because I worked hard for my business reputation and I don't want to be in the news because my staff member made some of my customers sick, or worse, someone died because my staff member spread a preventable virus that could have been contained. So, is it fair that an entity can have a rule saying, if you aren't vaccinated, a medical procedure, I won't employ you? And maybe it's okay for a private business. What about for government? And then if it then costs taxpayers thousands of dollars because a separate unvaccinated section of the building needs to be opened for those who don't have a vaccination, or something else, a greater cost of sick because people are sick or absent. What's fair? What's right? Where do we draw the line? Where do we come together, and where do we come together to argue about the lines that we want? The lines that we want to hold, the lines that we are willing to compromise on, and how do we move forward somehow? We accept inequalities and unfairness all the time, don't we, in our society? Some inequalities are acceptable, aren't they? We accept that someone who's become the Chief Justice or who's a Member of Parliament, regardless of what we might think of them otherwise as a human being or based on anything else they might have done, but they have the right to be treated with the respect of their office while they remain in office. If you don't like a Member of Parliament, you can't just go up and spit on them. We sort of think that you should treat them with respect. And if you're just a layperson, you have relatively less respect somehow. Maybe you can be spat on. Maybe that's just not acceptable anyway. We accept that great sporting heroes, big soccer stars, have natural genetic advantages. I'm never going to be a top rugby player. I'm barely going to be a top academic. And yet we look around and we accept that these people who are unequal to us, just for genetics, a roll of the dice, an accident, well, and that we accept that they probably worked very hard and they're paid salaries the size of a small nation sometimes just to kick a ball. The Ronaldos of the world, the top tier soccer players commanding 60 million US dollars, hundreds of millions, billionaires. I've heard one person describe watching English Premier League as watching two groups of millionaires running around a pitch in their pajamas. I think it's a cute expression, but you must note anytime you're watching soccer, European soccer, you're watching people whose wealth is measured in the tens of millions of dollars, mostly. Is that fair? Do you know who the richest person is in your country? Who is the richest person in your country? Do you know who the top 10 are? Do you know where they're holding their money? What about the bottom 10? Who are the 10 poorest people in your country? What do they have? Where are they? And is that inequity between the richest and the poorest fair? Is it fair? Should there be? There must be some gap between the haves and have-nots. But should it be so great? Is it right? Well, maybe your answer to that's going to depend on a lot of different things. It's going to depend on your values. It's going to depend on the time in which you were born or developed values. The point in time we are in history and what society's values are. If you paused the lecture earlier on and thought of your own ideas, you might have come up with something that captures some of these ideas. We could also expand a little on our questions. What should the role of law be in relation to crime? Taxation of income, taxation of goods, the taxation of services. What should the role of law be in the condition of our roads? Who can use our roads? What types of vehicles are permitted on the roads and the restrictions on their use? What should the role of law be in determining who is allowed to drive a fishing boat? What restrictions should there be, if any, on paddling a canoe or a kayak? What about a small sailboat? What about driving a passenger ferry? Should there be rules that apply to passenger ferries that don't apply to canoes? Or should there be some rules that apply to all vessels, such as following the directions of red lights and green lights on the waterways, such as the obligation for smaller vessels to give way to larger vessels? Is that just common sense, that we can have an agreed set of rules to keep us all safer? How should law address these situations? How should law maintain justice, protect people from the government and each other, promote culture or sustain and protect the environment. Okay, well, that's probably enough thinking for the moment about the ideal role of law. Let's rest our brains and look at how the legal system typically thinks about the ideal role of law. I'll leave you to read through the slide. The main point really to take away at this stage is that as lawyers, by and large, your training is to apply, your training that you've had has been to apply law in practice. Maybe interpret it or understand it conceptually to some extent. But this training that you've had so far has not been necessarily to understand law from a sociological perspective. It's not been to understand how the interplay of values, ideas, ideologies, and social concepts interact to create society of which law is a part. And how these complex interactions between actants in society and laws and these negotiations and interactions between different ideas and people create society. And then how all of these complex things all working together might be reflected in law, which is quite static. But this is always changing. And how these things inform and change one another over time, including the institutions and the people who are responsible for them. This is all stuff you need to learn. You'll need to be very observant. And there's a couple of slides, there's a couple of links rather here on this slide, which obviously you can't click, but the slides are all on Moodle, and I encourage students who think they might be in the top half of the class or, aspire to that, to check out some of these other resources. We're going to touch on both of these ideas later in the lecture, so if you take time to go and listen to some podcasts now, maybe go for a walk, stick on a podcast. Or have a look at the transcripts. You might gain a better understanding of what I'm talking about when we talk about the minimum standards framework of PALS in a few minutes' time. Should all laws and rules, regardless of where they are and to whom they apply, seek to adhere to universal principles? We've talked a little bit about justice, but what about the rule of law? There's a link on this slide to a PDF. It's quite short, and I recommend it to you. The role of the rule of law is discussed in this article from an Australian perspective and was written about 30 years ago. So, note its origins. It's an Australian thing. Oh, it's another foreigner. Oh, those white people. But I think you're all wise enough to know that wise words, if they're important and meaningful and useful to us, remain wise, regardless of their age, regardless of their colour. So go read that article. Think about it and consider right now how it might apply to what we've just been learning about. What about other values? So there's different ideas in society about how you might see the world, which instantly put limitations or constraints or draw brackets around what that person might accept or agree that law should or shouldn't do for us. Ideological differences, liberalism versus conservatism. Conservatism that things should be fairly static, that things should stay the same, that things should move very, very, very slowly. Liberalism, the idea that change is good and inevitable. There's more to these. In a little while, we're going to discuss Guy Powell's minimum standards framework, but first we're going to look at some of the other ways we can view society as a way of thinking about the role of law and in society and what it should be. The first of the things we're going to look at is a reading by Couret, which is featured in your topic notes. It's not specifically on Moodle, I don't think, and I'm not going to go into great depth on it. But I want to talk about a couple of things when we're talking about a liberal social perspective. If we're trying to determine the role of law in society, there is a whole school of thought of people who thought about that over the last several thousand years. I haven't read what people have written about it in every language possible that they might have written about it. I've only read what they've written about it in English and what other people who wrote in English thought about what these people thought. But that's as good as we've got right now. So, liberal socialism suggests that we have various forms, and we should have various forms of good governance and different institutions that interact in different ways to make our government effective for us and to ensure that our government reflects our society. However, under this school of thought, there's also the idea that there needs to be limits on the power of those who are governing. It shouldn't be unlimited. A monarch, a chief with unlimited power. We must limit members of parliament, prime ministers, presidents, and have checks and balances and systems that counterbalance. And this is the essence of a liberal society and of liberal socialism. But underlying concepts of society can weaken that particular model. When we look around the region, we see various underlying value systems that aren't consistent with the model of governance that we have in society, or rather aren't being recognized and utilized by the governance systems that we have. A liberal society values those checks and balances. It values the separation of powers. However, this doesn't mean it's the only way of doing things, not necessarily the best way of doing things. There are more socialist societies, there are communist societies, there are more capitalist valued societies, and there's variations of all of these. These aren't one or the other, these are bits of. China isn't a communist country. They have a political party called the CCP, the China Communist Party, and it's the governing party, and there is only really the one party. But in terms of how China is governed, it's not governed in a communist way. It's governed in a broadly economic capitalist way with various different configurations of government authority and power. So you can look at society through different, I guess, faces that it presents. As a capitalist, as a socialist, as a logical positivist, as a feminist, as a rationalist, you can adopt the lens of a different school of thought or a collection of ideas and use those collection of ideas to look through the world, at the world. And then your view of the world will be filtered, and what you see will come at your eyes, interpreted through these different lenses. We could apply any one of these lenses at any time and use that to look at our society, as we did last week, to identify problems, issues and things we want to resolve. And that's something we're going to do with the Guy Powell's minimum standards framework this week. and what you're going to do for your individual assignments. You're going to look at a law through the lens of PALS as an analytical tool. And you're going to identify what the weaknesses you've identified are linked to at their core. Are they not understood? Are they not fair? Then you're going to take off those glasses and you're going to put on a more helpful pair of glasses, something else from your toolkit. We can't just use glasses. Maybe it's a hammer. And you're going to put those glasses on, and these might give you a perspective on what to do about the sort of problem you identified. If law isn't understood, maybe we need education. Well, PALS didn't talk about how you educate society, but luckily lots of other people, and there's lots of other examples to read and learn from, about how do you educate people about law, if that was the problem, was lack of understanding. Well, Kure here suggests that a liberal society has a concept of justice that doesn't necessarily fit with what we have in our societies in the Pacific. There needs to be this interpersonal adjudication, he says. A sort of a courtroom setup. But contrast that with the Pacific notion of group rights or group justice or group adjudication. Contrast the idea of individual liberty and responsibility with ideas of group responsibility. Liberal societies focus heavily on procedures, getting the process right, making it transparent, making it fair, rather than necessarily having all of the rights or wrongs or the shoulds or the shouldn'ts explicitly defined in law, because those are the areas around which we will always debate. Is it okay to be gay and marry? Is it okay to beat your wife? Some of these are areas maybe we don't think we need to keep on having debates. However, we might agree that there should be fair procedures. So liberal societies are often very concerned about achieving good, fair, efficient procedures. By giving words specific meanings, we can use those words to explore different aspects of our society, and we already do this all the time. We talked about it last week. We have in-jokes with friends. We have social mores that govern our interactions, and we have languages in which specific meanings are attached to different words. There are social norms and different ways of interacting in a public space. And how you do that conveys different meanings to different observers. If you're storming around angrily, marching down the streets, hunching your shoulders and walking quickly, people might interpret those actions as having meaning, in the same way that words have meaning. I'm going to move past these next two slides. I don't need to specifically comment on them. But I will come to this slide. So what do you think? When you read Kure, as I know you already have now, when you think about this idea of a liberal society, is it out of step with how things are? It values legislation, but the common law can't be excluded from the lawmaking process in our societies. We've got all of these global influences on laws. We've got a dominant Western narrative, a dominant European or Eurocentric narrative. We've got a dominant Chinese narrative, all of which have different laws, systems, and different ideas about what the Pacific should be. Etzioni, another one of your readings from this week, well, he approaches this from a different angle. He discusses three ideal types of society as a way of giving us three different lenses to look at where our societies are today and what we think about our societies. Most societies will share aspects, hopefully not too many aspects, of a prescriptive society. Etzioni defines a civil society as those institutions that stand between the private world of individuals and the large impersonal structures of modern society. Institutions like our departments, our courts. The term civil society is best used to refer to societies that have a rich fabric of voluntary associations and other intermediary bodies, NGOs, that stand between the individual and the state, and whose citizens have the wherewithal required to sustain such a society. You're all critical thinkers. This is the work you're doing with your submission writing for your position papers, and the work you're doing in learning about law reform commissions. This is also the role, civil society, of the Fiji Rugby Board in the government's proposals to build new rugby stadiums a couple of years ago. They're vested stakeholder and they have a right to input in a new stadium as part of civil society. If you own a business in the CBD and the government proposes to shut down all roads around the CBD to allow more pedestrian access, you have a vested interest as part of civil society to comment. You're affected. Your business lobby, your chamber of commerce, or your men in business or women in business associations are all part of civil society. It's this rich debate. This public sphere. A good society, according to Etzioni, is an ideal type of society that relies mainly on moral infrastructure, families, schools, communities, informal social controls, mores, customs, to foster a core of substantive as opposed to merely procedural moral values. In a civil society, people do good things because the law says you must do good things, or you must not do bad things. In a good society, that normative pressure comes from all the individual actors and the environment to create pressure on us to behave in certain ways. We can see that this is somehow less liberal and more prescriptive than the ideas of a civil society, where it's the individual's rights all the way down. So long as it's legal, do what you want. But who decides what's legal? And obviously in practice, we exist somewhere between all of these, right? Yes, it's against the law to litter, but sometimes people throw things on the ground and they don't get punished. Sometimes your friends do it and no one thinks it's a problem, seemingly. Surely none of you throw stuff on the ground. The term prescriptive state might be used to refer to states that rely to a considerable extent on coercion and other tools to enforce moral values. The state decides what is moral, and they have a list of values that are considered moral, and you must adhere to them. For example, during lockdown, there were numerous prescriptive measures enforced. Pages of Etzioni on this are 359 to 360. Just making sure you're following along. Obviously, no society has ever been a truly civil society. Britain and the United States might approximate that order. A relatively pure case of a good society might be pre-colonial Pacific societies, although they might share a lot of traits with prescriptive societies like the rule of force. Modern prescriptive states can be seen in places like Afghanistan or the US under Trump, perhaps Putin, and Russia, or increasingly in the more right-wing authoritarian regimes popping up around the world. These prescriptive states are characterized by conservative values, outlawing abortion, banning divorce, requiring prayer in public schools, banning homosexuality, increasing criminal punishments in both scale and type. Controlled behavior through force is the essence of a prescriptive society. In any society, we need some element of force to support the state's authority. But I think we can all agree that we don't want to live in a society completely dominated by the rule of force. So if you look at these headings, this is how you should probably read the Etzioni article. Find the headings relating to some of these things and skim through them. If you want, you can read about the philosophical foundations of the three ideas that Etzioni talks about, and read about what he talks about as the basic role of law. I'll give you a bit of a summary in the next slides. But I've also directed you to Rawls to see a little bit more about theories of justice. Philosophically, a civil society rests on classic liberalism. You don't need to worry too much about that term and you won't be tested on it. The key point is that in a civil society, all discussions are from the point of view of citizens. Jürgen Habermas, who I've linked to a great podcast of there, on the public sphere, calls this the public sphere. Here in the public sphere, we as citizens discuss how justice as fairness is to be formulated and whether this or that aspect of it seems acceptable. In the same way, the claim of the ideal of discourse and its procedural conception of democratic institutions are considered. Keep in mind that the background culture in civil society contains all of these different doctrines that are taught, explained, and argued about indefinitely. That's what happens in a civil society: debate, 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 and engagement in the public sphere. It's the culture of daily life with its many associations. It's universities, it's churches, it's forums, learned and scientific societies, and endless political discourse of ideals and doctrines. So much of that is a quote from John Rawls's Political Liberalism. What Rawls is saying is that in a civil society, we as citizens must engage in debates over values, ideologies, and norms. These debates endlessly rage all around us, at the dinner table, in the media, in church, in private conversations, at universities, everywhere. People have discussions about right and wrong all the time. Look at what she's wearing. Did you see what he did? For John Rawls, the place of law in our society is in creating and sustaining fairness. Fairness for Rawls is what law should produce for us. Civil society for him is desirable because it affords and sustains debate. This precludes, it comes before, a shared understanding of the good to which society at large can subscribe and foster among its citizens. Law should produce fairness. It should produce fairness before we can even sit down on a mat and have a discussion about what good law will achieve, what good society can achieve through law. Before we can sit down, we must accept that law should produce fairness, according to Rawls. By contrast, a pure good society seeks to minimize reliance on written laws, not because the law preempts private decisions and makes us do things or not do things, but because law often undermines informal social controls by replacing them. We outsource just being a good person to law. Well, you got to follow the law. You know that you shouldn't kill somebody. The law says don't kill people. Well, in a good society ruled by ideology, thou shalt not kill might already be a law derived from a religious or social norm. Why does the government need to even write it down? That doesn't make sense. Thou shalt not kill. We've already got a law. In a prescriptive state, the rule of law is often replaced by law enforcement backed by the overt threat of force. The rule of the strongest state. The rule of our morality police. Etzioni's idea suggests that different societies have different roles for citizens and different virtues of what is good or bad about being a citizen. What is good or bad about being a person. What is considered virtuous or good in each of these three types of society? Well, again, what is the role of law in supporting those virtues that we uphold and say are virtues of society? If obedience is a virtue of society, well, law ensures obedience. It could do so with a very big stick. If what we want are good citizens, people who, however we define good citizen, are people that help others. So if what we want are good citizens, then the good society would encourage those virtues that we hold out as good. In a civil society, the virtues might include moderation, tolerance of difference, self-control, and the ability to think critically. I'm going to leave you to have a look through these questions. But in tying our thoughts together that we've had on Etzioni over the last little while, traditionally, most Pacific societies fit into the category of a good society in Etzioni's model. However, the modern state is designed to be a civil society. But the way things really work in practice is a mix of good and civil, isn't it? Maybe a little bit of prescriptive. Fiji, other places often use force, threat, bribes, influence, which is widely seen. That's quite prescriptive. What, if anything, does a lack of consistency in these types tell you about the difficulties in the functioning of law? It's all pretty complicated, isn't it? We each view the societies in which we live through our own personal lenses, based on our religion, our values, our family, and our idea of our place within society. This affects how we view the acceptability of what we see around us. If you own the largest company in the Solomon Islands or in Fiji, you might be quite satisfied with how society is structured. It benefits you. But if you're living in a squatter settlement, you might think society could do with some restructuring, perhaps to be a little bit fairer. And what do you think needs to change to achieve that? Well, we've had all this sort of social theory and all these ideas that there's different lenses or ways of approaching the study of law, and that's a key thing for you to take away from this lecture. You need to develop lenses through this course, different glasses you can take on and off. Look at the world through other people's eyes. As this course is taking you away from the applied practice of law to understanding or thinking about what law itself should be. You will assess how law is and evaluate how other people's versions of what the law should be might be relevant or valuable to you or your society or not. What sort of society do you want law to reflect? Do you want it to reflect more of a good society, more of a civil society, or more of a prescriptive society? What barriers do you see? What challenges do you see? Resources? Perhaps. There's quite a lot of reasons, probably, why law doesn't achieve its ideals, right? And that's going to be different in different places. We're not going to have one answer to this. We know the law doesn't always work. We've talked about it virtually non-stop in this course. Sometimes it doesn't fit the cultural context. Sometimes it is not relevant to the local environment. And sometimes it's just not conducive, given the politics of the day. Sometimes laws don't achieve their ideals because they're passed without consultation. Sometimes they don't achieve their ideals because there's just no way to enforce them. If you've only got one patrol boat or only 10 inspectors, how are you going to inspect thousands of fishing boats across thousands of hours over the year? You can make all the laws you want about how many fishing inspectors there should be and how many boats there should be. But law is just a tool, a limited tool, for addressing complex problems. Let's think about this a little bit more. How would you measure the success of the law and legal institutions in your country? What are you going to measure them against? How do you measure success? If it's a business, you want to make a profit. If it's a country, do you want to reduce the deficit even? Some economic theorists say that countries should keep deficits. You want to grow the economic pie, but is an economic measure of success adequate? Well, our economic model has given us the world we have now. How's that working out for us? Okay, so law is about more than just economics. We might measure justice, might we not? What can we measure in terms of effectiveness with justice? Well, we can measure many things. But which things should we measure? What effects of law are worth measuring to understand if we're achieving whatever we want to achieve? An example that's come up a lot in the forums is domestic violence, and the idea that incidence rates have increased over time and that they're increasing across the region. And if you're going to then measure the effectiveness of domestic violence legislation by the number of complaints and cases and crimes and reported incidents, then you're going to conclude that, well, this legislation isn't working. This legislation isn't working because, isn't the law designed to stop the incidents of violence? Well, is that how we measure the success of a criminal law? Does license and registration laws for vehicles stop people driving? Are they designed to stop people driving, or to sort of strongly encourage people to be licensed and registered and all of that? What's the goal? How do you understand whether a law's effectiveness when we're just measuring the numbers of incidents? It only tells you that we've measured this many this day, this week, this year. It doesn't tell us how many people were punished. It doesn't tell us how many survivors of violence were supported. It doesn't tell us how many children were saved from violent and horrendous and unproductive households and protected, and housed somewhere else, hopefully with other kinder family. How do you measure the success of a parliament? The number of bills passed per year? That's the Fiji government's approach until recently. You can pass a lot of bills when nobody debates them. Maybe a better measure is the number of bills debated each year in Parliament, or the number of hours and number of bills. Or perhaps the measure should be the number of people lifted out of poverty each year as a proportion of the population. Are we getting more wealthy, healthy, and better off? Healthy, wealthy, and wise? Are things improving, or are they not improving? And how do we measure whether those things are improving? Literacy rates? How do you measure literacy rates? How do you measure the success of the judiciary? Do you measure the number of cases that each magistrate disposes of each year? Do you measure how long each case has been open? For example, you must close this sort of case within 6 months. That's our target. Or cases involving gender-based or sexual violence must have a first hearing within 2 months and a full hearing within 4 months. How do we measure this? And with all the things we are measuring, what other things aren't we measuring? For example, justice. How do you measure justice? Well, it's a really good question. And we had a link to the World Justice Project, which tells you that there's many ways to measure justice. But it is just as complex as measuring the efficiency of anything else. How do you measure how well a parliament works? Well, there's information available today that can tell you some ways of trying to measure that. But this isn't a rule of law course, and we're not measuring it today. The point is for you to take away that if we are measuring something, what aren't we measuring? In terms of why law doesn't necessarily achieve all of its goals, Guy Powell identifies all of these incompatibilities. Sometimes law doesn't achieve its ideals because of incompatibilities between different ideas. Different ideas about what is right and wrong, what is fair and just. Sometimes it doesn't achieve its ideals because unwritten customs aren't reflected in written statutes, and everybody feels uncomfortable with the way the statute is applied. There are many reasons why law doesn't achieve its ideals, and what we're going to do next is step away from the slides a bit and consider another lens for looking at law. This perspective can give us some specific insights into how the law is or isn't working, and these insights can help inform practical solutions for fixing the law, changing the law, or making it do whatever it's not doing, or at least do whatever it's doing better. So there's a link on this slide that obviously you can't click, so go to the links in the slides in Moodle. So what is this article? I'm just going to assume you're opening it. I'll tell you what, why don't we open it right now? Okay, so you should have the Guy Powell's Minimum Standards Framework here with me by Anita Jowett. So what is this article? Well, let me give you just a little bit of background. Once upon a time, USP started a law school. That law school is the one you're currently studying at, and it was established in 1994. This year is 30 years of the USP School of Law. Go and ask about the celebrations that are happening. Get in touch. Maybe offer to help out. The first graduates started coming out in 1997 when it was first established. LW305 was a compulsory course. It was compulsory because one of the major reasons for establishing a law school in the first place was to ensure students of a Pacific university were well versed in developments in applying and studying their own laws. Anita Jowett first coordinated this course many years ago, and she coordinated it again many years later. Anita Jowett wrote this article during that time because PAL's minimum standards framework has been taught at this point in this course every year for more than 20 years. More than 24 years now, maybe. Why? Well, because a lot of people smarter than me and who came before me thought that Guy Powell's minimum standards framework might be a good way of getting you, as students, to think about law, analysing it, brainstorming about it, and identifying things that work and don't work. One thing I should say is that the framework we use was never originally created by Guy Powell as a framework for analysing law. Powell's statements on analysing weaknesses of law weren't initially intended as such. This framework is something Anita has developed and used in this course, and I think it's very useful for us. She explains why, in this article, the majority of your training is about practicing law, solving problems. You learn IRAC and other methods to solve problems, but they don't provide you with frameworks for thinking about how the law should be. IRAC doesn't tell you how the law should be, it tells you what the issue is in a particular situation involving law. You might state what the law is, discuss it, and then come to a conclusion. But should that even be the law? Should it be different? That's not usually the question. That's not your client's question. There is a law, and your client needs you to do something about it. Even judges and parliaments don't always think about what the law should be. The law reform process is one thing that is designed to discuss that. But we know that the law reform process, the referrals to committees, the debates, the civil society engagement is not always as robust as we might like it. Yes, the courts, parliaments make law, and ultimately the courts are just interpreting and applying the law of Parliament. At the end of the day, we respect judges and their learning. Sometimes constitutions help. They allow a judge to look at the idea of substantial justice or to consider conformity with custom, as in Vanuatu. This is the idea that there is this idea that you as students and as future lawyers who will hold different roles in your lives, you should get some training in these normative theoretical approaches, this should or how should law be. That's what this lecture and all of the material we've presented so far is trying to get you to think about. We believe one of the best ways of doing this is by saying to you, here is the Guy Powell's minimum standards framework. Go away and apply it to a law. So is this still the core learning for this course? Well, yeah. So how do we improve the performance of law? Well, according to Powell says law should be responsive and understood, and dispute resolution should be fair and effective. Legal services should be appropriate and available. You'll see from the topic notes when you go to them, or if you've been going back to them, that we're going to take Jowett's interpretation of this and say, well, actually, all aspects of the legal system and the laws within it must be responsive, understood, fair, effective, appropriate, and available. It's a mouthful. 6 things. But we can use these as a way of asking questions about law. This might help us determine whether we think the law is working or not, whether it is good or bad, and why. For example, take the no jab, no job policy. Laws mandating vaccinations for certain people. Are those laws responsive? What do you think? Do they respond to what's happening in society? Yeah, there's a killer virus on the loose. How do they respond? What's the debate been? What's the reception to that debate? Right? Did people understand what no jab, no job meant? Did all of the people to whom those laws applied, understand the consequences? Well, it's not that complex. It's straightforward. It's not tax law. What about tax law? Do you know how income taxes apply to you? It's easy in Vanuatu. What about outside of Vanuatu? Are the income tax laws fair? What is fairness? Fairness is justice. Are the laws delivering justice? How do you know if they are or they aren't? Case studies. Find a person to whom the law was applied. Work out how they were treated by the law. And ask, was that process fair? Was the procedure fair? Was the civil society outcome fair? Are these systems of law effective? We talked about the trouble of measuring effectiveness, but if a law is supposed to stop something like pollution or smuggling or drugs, is it stopping pollution? Is it an appropriate way of achieving that end? Is it stopping pollution in the right places? And is the law available? Can you even enforce the law? Are there remedies? Even though you're protected from being assaulted, according to the law, if there's no police officers around to help enforce that, how does that protection actually work in practice? So, I have stressed, on the next slide, I stress that the framework should be used for brainstorming. So, a lot of students do get caught up in the final assessments on this assignments for the course by just analysing a law using Powell's framework without saying much beyond that. We want you to use Powell's framework as a stepping stone. Start by analysing a law and then asking, well, what is the problem? Is the problem that we see that the law is not responsive or that it's not fair? What's the essence of it? And then most of your paper is meant to be about how are you going to strengthen the law. I know, I'm asking you to do a lot in this course. In your Topic 7 guide, which is quite extensive, there's commentary from Anita Jowett on the Kure article, commentary on Etzioni, and commentary on the minimum standards. You might want to look at that. If you look at the Topic 7 notes, you'll see an example of a law from 2002 regarding violence against women. My goodness, has this been a big problem for that long? Why is it still a problem? There was a bill that was challenged, and there's a case that might indicate why the Act hasn't been successful. When you make a new law, you need to let people know about the law, for example. You need to inform them of its contents and its specifics, how it applies, what its nuances are. If the police come to the village, what do you do? All of that is part of implementation, part of a way the law is brought into effect. We know there's a lot of laws that pile up without proper implementation. Law should be understood. Is it understood? No. What's the solution? Increase understanding. What strategies, policies, or approaches can you adopt as a government to increase understanding of law? What about when there are disputes? If someone is charged with a crime or a company sues a person in a civil matter, a theft, for example, what makes the process fair? There are many ways to look at that. Was justice done? What does that even mean? We can say that procedures should be fair. Let's say using a case study of a person who was arrested. How were they arrested? How were they interviewed? How was the information gathered? Did they have the right to a lawyer? Did they have access? Were they given food and water? Were they given an opportunity to use rest facilities? Were they able to sleep? Did they confess? Or was all the information gained in a fair way? What about the actual trial process? How did that unfold? Did each side have equal opportunities to present evidence? Did rules of evidence apply equally? Was there equal access to the evidence? Was there disclosure of evidence beforehand? Were there no surprises from the prosecution so that a fair defense could be made? Was there an open and fair process in the courts? And what about effectiveness? If we're looking at a law, if you have opportunities for domestic violence orders and you go to court to get a domestic violence order restraining a person from attacking someone and they ignore that order, is the law effective? Maybe not. Is the law enforced? Only if there's people to enforce it. So how do you increase effectiveness? Maybe you need more police officers, more training, more resources, better ways of protecting people. What about appropriateness? Well, appropriateness seems a little blurred, but Jowett has linked appropriateness here with available. Well, let's say the law exists, but it's only published in English. Firstly, that's not available to everyone. Second, it can't be understood by everyone unless they understand technical English. In fact, even if it was available in Bislama or Hindi or a Fijian language or another language, multilingually so that people in your society can access it, can they even understand the law anyway? So is that appropriate or not? If you have a particular province or town that has a water shortage and you make a law permitting the building of a dam that blocks the river, causing all the villages downstream to have no water, is that appropriate? Is it fair? Right. So you can see how all of these ideas interlink a bit. But because the concepts overlap, what we want you to do is to use them in ways that help you to identify problems with the law. By starting with the question, is this law understood? Is it appropriate? Is it available? You're going to develop some insights into how to solve the problem or that you've identified with the law and how you're going to go about strengthening that, which we'll cover in the second half of semester. It's all well and good to have a process for obtaining a domestic violence order, but if you have to file that directly at court and you live on an island with no courthouse, then the law is not available and therefore the law is failing. Or if you live in a village, in a town, but that village is 2 hours by muddy road away from anywhere that's safe or a court, is it appropriate to say, oh, well, is that a system available? Is that mechanism of justice appropriate? As Anita Jowett notes in her commentary, in the topic notes. This is a way of scratching the surface. I want to see in your individual papers you using the framework to say it's clear that no jab, no job laws are not fair because, or it's clear that they're not appropriate for frontline health workers for some reason, or the law isn't available because you can't get a vaccine on an outer island. Maybe you're looking at fisheries laws and you're interested in whether or not people understand fisheries laws. Are the rules on when you can catch certain fish understood? How do you increase understanding? Penalising people in markets. Availability of law seems more about protections and remedies, doesn't it? When can you actually benefit from it? Appropriateness seems to relate more to the content and scope of the law. Effectiveness, always a good one. Can you find cases where the law has not worked or is not working? Gives you some evidence that it's effective or not effective, doesn't it? So there's study tasks throughout the topic notes that I really commend to you. This is part of building your skills and expertise. So that's PAL's minimum standards framework in a nutshell. And this is a rather long lecture on the ideals of law, the different ways we can think about what laws should and shouldn't do, and a framework we're asking you to use for your individual assignments, for your, they're all individual assignments, but your analysis of a law paper. To identify ways in which a law you've chosen does or doesn't work, and to guide you in thinking about solutions. Solutions might include law reform, but also include ways of strengthening laws that come from promoting the laws, from increasing their normative force. A preacher at the pulpit shouting, "Vaccines are the devil!" Even if you think vaccines are good, you might be shocked and more hesitant to get vaccinated. If your father's particularly racist, you might develop particular views influenced by that. So, how do you influence those people and their beliefs about laws or about things that they believe in? So, laws and how we're governed by them are influenced by a wide variety of external parties, and how each of us individually views the law and what it should be doing in society is incredibly important. You need a framework, PALs. Once you've identified weaknesses and analysed them, you can start thinking about strengthening law. Although that's going to wait until after the break. There's a lot of materials, as I've said, for the lecture for this week. I don't expect you to even necessarily read through all of this, chip away at it. But you've got a break coming up. There's a lot of material here that should keep you going and serve you well as you continue to work on your assessment. As always, if you have any questions, get in touch, and I'll see you next time. Bye for now.